Good day to you. And as you well know, in the internet age, in an era of social media, there's a lot of things that get thrown around in terms of what people are saying about others, especially when arguments break out. You can see people call others names like asshole on social media. You can see people accuse others of really unconventional and in some cases illegal behavior, accusing others of having affairs, for example, which might also be illegal if the person they're having an affair with is underage. You can see all kinds of really what I consider to be nasty things thrown around on social media. The question that I have for you is, what exactly is illegal in terms of what you're saying on social media if you're bad-mouthing somebody else? And what is illegal? And would you be able to say those same things if you were interviewed by a legacy medium, like a television reporter? Would you be able to say the same things, and would the law apply to you the same there? These and other issues are what we're discussing today because we're taking on media law. We're taking on Chapter 14 as we head into our second to last class here in Intro to Mass Media. We're going to be talking about a lot of court cases today. They may become confusing to you. You may want to do something with your memory techniques to help you with the quizzes for this particular chapter. We are talking about court cases today as we discuss the law as it relates to media. And a lot of times what we're talking about with media law doesn't have to do so much with media organizations themselves as it has to do with what they are covering in terms of real life events. And they are covering these in news reports. So that's what a lot of our focus will be on today. Let's start out by saying that the First Amendment is at the core of all media law, and in fact all law in this country. You know the First Amendment, right? You have the Constitution, which was written in Philadelphia, just 2.5 hours south of East Stroudsburg. And then it was revised a couple years later saying, oh, we forgot some things. And the very first thing that we forgot is an amendment that says that Congress shall make no law respecting an establishment of religion, shall make no law prohibiting the free exercise thereof, or Congress shall make no law abridging the freedom of speech, or of the right of people to peaceably assemble, or of the right for people to petition the government for a redress of grievances. Now, I kind of botched the delivery of that law there, but basically it's guaranteeing people free expression. You can't be told what to say or what not to say. However, even though we have the First Amendment, the Supreme Court has ruled that, no, that's not the case. The First Amendment is not absolute, as we would consider it, meaning it applies in all cases, that the Supreme Court has ruled that the First Amendment is actually relative. So, for example, it's illegal to yell, "Fire, fire!" in a crowded movie theater if there is no fire, because somebody may get trampled and may get hurt. And so the First Amendment is not, in fact, absolute. There are limits on the First Amendment. Still, we understand in the United States and elsewhere that the First Amendment is critical to democracy. The First Amendment is critical to democracy because we need people to be able to express the largest variety of ideas possible so that people making decisions about ideas are going to have access to a wide variety, and they can choose the best ideas over the worst ideas, and that these ideas will get flushed out in a big debate that takes place. That's what the First Amendment is supposed to provide, the ability for a democracy to function, because there is more transparent information than information that remains hidden. We also want to make a final comment in our introduction as we round out the introduction here, that the First Amendment protects more than just popular speech that we would consider to be in media. It really protects all forms of speech, including conversations that you may have texting somebody else. And we also want to make the point that the First Amendment covers individual speech and media speech. That's right, speech on media, including commercials, advertisements, is actually considered to be speech, and that's what the First Amendment covers. So let's talk about the roots of free speech. How did we get an idea in our country that free speech should be valuable? And yes, in the American colonies, newspapers did have to receive a license to operate. We've talked about that before in this class. And so what happened in the colonies with regard to this law to leave an impression that free speech is very important? Well, it starts with a publisher named John Zenger. John Zenger, Zenger, and his wife, by the way, Anna Catherine Zenger. They were independent editors and printers working in New England. And one of their publications accused the New York governor, Governor William Cosby, of replacing New York's Supreme Court justices that he replaced them because he didn't like them, not based on whether they're doing a good job or not. That's what they had in their publications. The governor reacted by throwing Zenger in jail for libeling him. We're going to talk about that word libel in a few moments. It's one of the laws that we're going to study today. But ruining his reputation, that's what that's about. And the jury found Zenger not guilty. They found him not guilty, and they said that actually, if you're telling the truth, you can't be punished for it. So that opened up a principle or a precedent, as we refer to it when we talk about law, that will then continue on through other court cases, that what John Zenger actually said was true about the governor, so he can't be punished. All right, also in colonial America, we're talking about the roots of American free speech, we have these acts that were passed called Alien and Sedition Acts. They were passed by Congress. They're both separate, but they both basically have to do with false or malicious statements that are said against the American government and making those statements illegal. One of the first persons tried for this was a Scotsman. He was a Scottish immigrant named James Callender, Callender. He was thrown in jail in the 1800s for criticizing the Adams administration, and this is what he wrote. It's kind of funny by today's standards. He wrote that President Adams was repulsive. He was a repulsive pedant, P-E-D-A-N-T. That's not the same as pedophile. Pedant is somebody who's really boring and is speaking to somebody at a very juvenile level. A repulsive pedant, a gross hypocrite, and this is the worst accusation of all, an unprincipled oppressor. Strong language, right? By today's standards, we would laugh at that kind of criticism. James Callender, he was thrown in jail for that. And he was thrown in jail because he was criticizing a government. So he was thrown in jail under sedition, which is illegal to criticize the government in a way that's going to cause a lack of respect or belief or sustainability, a belief in or sustainability of the government. The sedition and alien acts, they were used a lot during war times, especially World War I, where you're trying to make sure you're not leaving an opening for any enemy because you're at war. And actually, Congress passed the Smith Act. The Smith Act makes it a crime to advocate the violent overthrow of government. So interesting, right? Because of the insurrection that happened on January the 6th. Doesn't that fit in? To advocate the violent overthrow of government? That's, of course, for you to decide. You can look at the video and the speeches that were given prior to the march on Washington. You can decide for yourself, but it's a relevant issue when we're talking about alien and sedition acts. And actually, we have these things happening in the modern era after 9/11. After 9/11, the U.S. Patriot Act was passed. That was a sedition and alien act. It permits the Justice Department to tap into your phone if you're making overseas calls. It prohibits people, this is one of the most controversial components, who have been served a warrant from telling others that they've been served a warrant. And so it's been an act that's been criticized, but it's in that same kind of vanity of alien and sedition acts. Now let's move to the other side of the equation, that's protecting individuals, and we're going to focus on libel law here. This is designed to protect individuals from abuses by the media. Basically what libel is when the media hurts your reputation. Like if you go on social media and you accuse somebody of being a heroin addict, or you accuse them of being infidel to their partner, or if you accuse them of having a mental affliction, those are statements that can affect the way a person can function in society, the jobs that they have access to, their relationships with others, their own well-being can all be affected by what is said in the media. And so individuals have to have protection, and that's what libel law is all about. And there are three components to prosecute a libel case successfully. The first component is defamation. Defamation, you have to prove that a person's reputation has been damaged. People know about the reputation. It's hurting them. They're not able to get a better job. They couldn't keep a job. They got fired from a job. They can't change jobs. They have a mental condition where they need counseling. This is all about damaging somebody's reputation. So that's the first component of libel law. The second is identification. Identification means that whoever's talked about in the story has to be specifically identified. You can't be talking about university presidents being drunks and then say, oh, this university president gets to bring a libel lawsuit because the article is about them. No, it has to specifically identify a person for a libel lawsuit to go forward. And then the third thing that has to happen for a libel lawsuit has to go forward is the publication must be seen by somebody other than the author. If you create a web page and you libel somebody on it and nobody sees the web page, it's not really libel. Same goes if you do a news story and you don't actually run it on your radio station or TV station, it's not satisfying that third element, which is publication. Now, at the same time, the media can defend themselves against libel too. That's why we have a court system, right? It's supposed to ensure fairness, that both sides get a fair hearing. So the media has defenses against libel as well. Somebody's suing them for libel. Number one is truth. We already talked about that with Zenger. If the media are telling the truth, they're generally on solid ground. Secondly is a term called privilege. Privilege is the most difficult one to understand. Privilege has to do with certain parts of the libel law say that statements made in certain venues cannot be brought out into the open. Certain proceedings of Congress, for example, are confidential. If you go to municipal meetings in your local government, like East Stroudsburg Municipal, they will sometimes go into what's known as executive session, where they have to talk about personnel matters, and those are not for the public. And when they go into executive session, they go into a private room, and then the public who's attending don't get to hear it. So matters said in executive session could not be brought out into the media. That's what privilege is all about. If it's supposed to be kept in a private venue, you can't report on it. And third and finally, a defense that media have is opinions. You can have an opinion. You can call a governor or a senator or a representative. You can call them an idiot. You can call them a jerk. That's perfectly allowable. That's an opinion. So those are the ways that media get out of court cases against them. Now we're going to go on to talk about how certain areas of the law, particularly libel, have been affected by major court cases. And the court case that we want to talk about is called New York Times versus Sullivan. That's always the format of a Supreme Court case, New York Times versus Sullivan. So basically what this was about was there was a civil rights group in Alabama that was sympathetic to Martin Luther King and his civil rights movement. So they took out an ad in the New York Times and they published a story about what was happening in Alabama. And they talked about how they didn't mention the police commissioner by name, but how the police commissioner had organized a building where students were protesting, and that building being surrounded, and the students were reported as singing "My Country, 'Tis of Thee." And well, guess what? There were a lot of factual inaccuracies in that published advertisement. For example, they never sang "My Country, 'Tis of Thee." But is that really important to an ad that's making a case about racism? Well, that's what the Supreme Court agreed with, because here's what happened. The Alabama Supreme Court found in favor of the police commissioner who brought a libel suit against the New York Times. They found in favor, but upon appeal, and this is the way our court system works in the United States, cases get appealed and they make it to the highest court in the land if they make it. That's the Supreme Court. The Supreme Court overturned the appeal and said, yes, there were false statements in this advertisement, but they were made in good faith. They were not made out of actual malice. So what this case established is that you cannot sue a media organization for libel just because the media organization got some things wrong. You can't, if the media organization tried through due diligence to cover all the bases and they just happened to interview a couple sources who gave bad information, that's not their fault. So that means that media can actually be factually inaccurate and not be sued for libel. Very interesting Impact Act case. 1960 is when that case was.
Now let's talk about another court case, involving libel and public figures, because public figures are set apart separately from the average citizen when you're bringing a libel case. So the case that made this distinction was Gertz versus Robert Welsh in 1974. And Gertz was an attorney who was accused by the John Birch Society, which is a conservative society in the United States, conservative political society. Gertz was accused of being a communist. He was accused of being a communist, and he sued for libel, but the courts ruled no, if you're a public figure, you cannot sue for libel if somebody's accusing you of something, even if it's false, even if it's malicious, because you have a higher standard. That's what this court case says. You have a higher standard if you're a public figure. If you're elected, or if you're an entertainment celebrity, you have a higher standard, because the reasoning is you're using the media to become famous and rich and powerful. You're using the media to get elected, to let people know about your positions. You're using the media to let the media know and that your fans that you've got a new movie out, so you're going on talk shows. So if you're a celebrity, if you're an elected official, and you use the media, then you can't get upset when the media turn against you, like Britney Spears or Meghan Markle. You can't use it against you and try and say this is a libel case. So there's a different standard. There's a different standard. And one of the most recent libel cases which was successful was a high-profile case at the University of Virginia, where a newspaper reported on a fraternity that had allegedly conducted a gang rape. And this case proved to... Actually, the case didn't go to the courts. This case did go to the courts, and the newspaper was successfully sued for libel because it had sources it interviewed, and the sources gave false information. And so the fraternity got an award settlement. The members who were described in the article got an award settlement, all by Rolling Stone because of this libel case. All right, now we're going to go on to another area of law. This area of law is different from libel. It's called invasion of privacy. This is an area that a lot of people wonder about in the social media age because of the possibility of revenge porn and all the other ways that you can get people back based on what you know about them and what you can unlock on your phones, basically, that used to be previously private information. You know, if I ask you questions like, how much money do you have in the bank? Or what's something stupid you've done when you're drunk? Or are you taking any medication that would be considered psychiatric medication? These are questions would make the average person very uncomfortable. They are private questions. And so what right do people have in the media to expose that kind of information? It really depends on the context. As Oliver Sipple found out, Oliver Sipple saved a president's life. He's a former military person, and he blocked the person who was going to shoot President Gerald Ford with a gun. Oliver Sipple did. But the media got a hold of some information that Oliver Sipple was gay, and they decided to report that. And Oliver Sipple sued, and he lost. He lost because previous publications had also run stories on him being gay. Now, why is being gay relevant to him saving the life of a president? That's a thorny issue to tease out. What is in the public's interest? Do they need to know that gay people are as courageous as non-gay people? Is that something that could be made as an argument to run that story? It's a very difficult area to sort out here, the right to privacy, and especially because there are no explicit constitutional laws that are protecting privacy. Privacy laws are all implied. They're implied by the Fourth Amendment. The Fourth Amendment limits searches and seizures. Some of you know about that when you drive a car. If you have something in the car, you're aware that police can profile you, and then they can ask you, do they have the right to search your car? That's where this Fourth Amendment protects you from unwanted searches and seizures. So that's an area of the law that kind of has to do with privacy. Also, the First Amendment, which we laid out to start the class, that's the freedom to associate. It has a freedom to associate clause, which prevents the government from requiring a group to release a membership list. Like even the KKK doesn't have to release who its members are because of that First Amendment, protecting their privacy. And then we also have the 14th Amendment. And the 14th Amendment limits some disclosure of personal information, but these amendments were all written well before the social media age. So we have to look also to court cases to figure out what privacy law is all about. And various court cases over the year have established 4 areas that you have a right to privacy in. The first area is intrusion. Intrusion is like trespassing. It's like somebody coming onto my lawn here without my permission. And that's the same way about going into your social media, going into your private videos, going into any media content that you've created. It's treated as an extension of your body. That's your private space, your phone. And so intrusion law protects you against people intruding. A second area of privacy law is embarrassment. Embarrassment, reporting on somebody for being naked or falling down a step or being gay, like we talked about, with an attempt to embarrass them. This is a harder one to successfully prosecute in today's day and age, but still there are privacy laws. And then we have the law about false light. This is a third area, false light. That's where you portray a person in a light that is just not true. Like if you go and you do an undercover report on prostitution in Philadelphia, and you take some videos into the city and you shoot an area where prostitutes congregate, but you also have regular people walking through those spaces who are recognizable, but they're not there for prostitution, but your video coverage makes it look like they are. That is false light. Same with you if you go to the arrest of a drug dealer and you capture a college student walking behind the sidewalk. You need to be careful about false light. And the final area is misappropriation. Misappropriation has more to do in the commercial area of law. Misappropriation is when you use a person's image or their name without their permission, and it's benefiting you from a profit standpoint. It's like if you take an artist like Bruno Mars or Miley Cyrus and you play them at your restaurant, and people are coming to the restaurant, they're like, hey, I like this music, I'll eat here. And you're benefiting financially from misappropriating their image without their permission. And so that would be illegal. That's why you pay, by the way, license fees if you own a jukebox in a restaurant, so that your jukebox fees, the jukebox songs that you're playing, they're being credited for bringing people into your restaurant. That's what misappropriation is about. You can't make a cardboard cutout of Tiger Woods and put him in front of your golf shop and get people in the store. You have to get his permission and a contract, really. That's misappropriation. Now, as I said, social media and privacy are still playing out. There is a California case that says that someone who posts complaints on social media, and then those complaints are published in a newspaper, those are not subject to privacy protection. They are now in a newspaper, which is for public consumption. However, a New Jersey case has ruled that if you post something in a closed wall platform like Facebook, where you have to agree for somebody to become your friends, and that information then gets let out into a wider setting, that is the basis for a libel case, because you have a right to expect that your personal information will only remain among friends. So think about that as you navigate your own social media. Now let's move to another area of law. This area of law is called free press / fair trial. Free press / fair trial. And basically, the rights of having a free press sometimes conflict with guaranteeing a person who's accused of a crime of having a free and fair trial. So the Sixth Amendment guarantees an impartial jury for individuals. So you can't have people up there who have already decided that you're guilty, right? And the 14th Amendment requires an impartial jury for criminal defendants, people who have committed murder and those kinds of serious crimes. But at the same time, the press wants to cover these stories, and so sometimes the press can accidentally or on purpose create a perception of guilt or innocence that should not be there before the court case has taken place. That's where you have this conflict. The most important case in this area is Dr. Sam Shepard. Dr. Sam Shepard, that Supreme Court case in 1954. Dr. Sam Shepard was a doctor, a medical doctor, and his wife was murdered. And when police came to interview him, he talked about a bushy-haired intruder that he fought off in the house, immediately bringing up racist allegations that he's talking about an African American and inciting racist feelings to try and gain sympathy. Well, after further investigation, it turns out Dr. Sam Shepard was having an affair. And so the newspapers and the media, when they found out about this, being the 1950s, they went berserk with reporting on this affair. Dr. Sam Shepard then was convicted. he was convicted of murder. But then he appealed the court case, and the Supreme Court overturned his conviction. They overturned his conviction not because he was innocent. They overturned his conviction because he didn't get a fair trial, the Supreme Court said. They called it a carnival atmosphere under which he was tried, with headlines screaming, "Dr. Shepard having an affair, brutally murders his wife." That's the kind of affair, that's the kind of context that was going on. So the Supreme Court in this particular case conjured up some remedies, they called it, remedies for future cases to ensure a fair trial. Those remedies include a gag order, meaning that the judge can say nobody who's involved in this case is allowed to talk to the media. You've got a gag on your mouth. That's one way to combat potential unfairness. A second way is sequestering the jury. Do you know that term, sequestering the jury? That's where you say, we're going to make the jury stay by themselves in a hotel with no access to media, no cell phones until they come up with a decision. That way they won't be influenced by outside media. Postponing a trial is a third way this is done, saying we're going to do the trial later after the local emotions have calmed down. And fourthly, changing the venue for a trial, saying we just can't hold it here. People are too upset. Too many families have been affected. That's what happened with Timothy McVeigh. They both postponed his trial. He's the guy who bombed a federal building in Oklahoma City and brought the whole thing down and killed many federal employees. And they also did his trial in Denver, Colorado, as opposed to Oklahoma, so that he would get a fair trial. And he did receive a trial where he was convicted and later put to death. Cameras in the courtroom is another issue that has to do with free press and fair trial. If you put a camera in the courtroom, what does it do to the deliberations that take place? What does it do if jurors know that they can be seen? That makes them nervous, right? Because then they can be blackmailed. Their houses can be found out. Their family members can be threatened. So you have to be careful about showing jurors. And also, when you show a person who's accused of a crime, they can have a different persuasive quality just based on the way that they look. If they look really innocent, or if they look evil according to our standards. I saw a guy in a courtroom when I took my students to Philadelphia, federal courtroom. He was Azerbaijani, that's a country, and he was accused of running illegal guns into the United States through a country in Africa, a third country, Leone. And he looked like the caricature of an evil person according to our movies. He had the big black beard. He had scraggly hair. His eyes were dark. I'm ridiculing this on purpose. That's what can happen with cameras in the courtroom. So generally speaking, cameras are not allowed, but some states do allow them in the courtroom, but federal courts do not. The Supreme Court does not allow cameras in the courtroom. Now let's move to the item of controlling the press, another area of law, controlling the press. And Congress and the courts have repeatedly tried to put restrictions on our mass media, to control the mass media. There was the case of Cohen versus Cowles, Cohen versus Cowles, Cohen and Cowles. Cowles was a media company. And what this involved was there was a Republican who was running for governor in Minnesota. His name was Wheelock Whitney. It's an unusual name. Wheelock Whitney running for governor. And he found out that his opponent had been arrested for theft. And so Wheelock Whitney hired a PR firm headed by a person named Cohen. And he wanted Cohen's firm to reveal this information to reporters, but Wheelock Whitney didn't want to seem like the person who was revealing it, because that would be unseemly, at least in those days. So two newspapers, they ran the story and they interviewed Cohen. And Cohen wanted anonymity, but they revealed Cohen anyhow in the story. So Cohen sued, and he won that media have to live up to their contracts, that the media promised that they would keep his name anonymous, and they did not. So that is a control on newspapers, that if you are a journalist and you get a person to talk and they say, I'll give you the information, but I want to remain anonymous, you have to live up to that. And the reason for that is because we rely on anonymous comments, again, to help our democracy. If we don't have people coming out and saying there's corruption going on here, there's bribery going on here, there's something happening that's wrong, if we don't have people saying that because they're afraid they'll be fired, they're afraid that their lives will be harmed, then we don't have the ability to root out corruption. So that's where controlling the press comes in. Another area of controlling the press is prior restraint. Prior restraint is a judicial order that stops the media from publishing something. Two court cases here speak to this. One was the Pentagon Papers, where the federal government tried to stop the New York Times from publishing information on actually a study that the Pentagon did itself on the Vietnam War, because the Pentagon felt that it would hurt the chances to be successful in the war. It wasn't actually even a war. It's called a conflict. We never declared war on Vietnam. The New York Times sued the federal government and won. And they proved that publishing these papers do not give any immediate danger to the public. There's another case there about Jay Neer, who was a publisher of a newspaper called the Saturday Press. It was an anti-Semitic newspaper against Jewish people. And this paper was allowed to continue because it was ruled that unless the offense is threatening our national security, offense that's an offense to just one racial or ethnic group is not enough just because it's offensive. Now let's go into journalists and the police. This is an issue that was brought up very much by the whole last year and a half with the outcome of the George Floyd murder. And so generally speaking, there are lots of cases where journalists have been attacked or even arrested trying to cover protests such as George Floyd protests. You can read the story of a black male who was arrested just trying to do his job for CNN, recovering. So we have a problem where police are arresting journalists based on racial profiling. And in fact, many states have what are called shield laws in place just for this purpose. Shield laws are designed to protect journalists. Each state has a different shield law. Pennsylvania has a shield, like holding a shield up, right, to protect yourself. A shield law makes it, gives the journalists the protection to not have to reveal confidential sources. Once they reveal confidential sources, the journalist loses all credibility. You can't go to people and say, listen, I need this information, I'll keep it confidential. Once that is violated, you'll never get confirmation, confidential information again. So shield laws are designed to protect reporters, although some courts still try to put reporters in jail for not revealing their sources. It's tough because if you know that there's a source out there who can tell you who was the murderer of someone, shouldn't they be forced to reveal that? It's a difficult one. Now let's go into free speech and students. Generally speaking, students do not have free speech if they're at a college or a high school. There's a case, Hazelwood versus Kuhlmeyer. Hazelwood was a school district. Kuhlmeyer was a principal. And Hazelwood was all about stories that students were running on teenage pregnancy. And the principal found out about this and said, you can't run this story. People are going to know who the females are, and that'll hurt them in their classes. The newspaper said, oh, we'll delete the names. He said, that's not good enough. They'll still know the story. This case went all the way to they'll still know the identities of the females. This case went all the way to the Supreme Court, and the principal won. And the ruling is, if your newspaper, radio station, or TV experience at your college or university campus or your high school is an extension of a class, if it's part of a class, just like WESS radio at ESU is a part of radio practicum, the class, then the university has a right to censor and to regulate the content. Now let's go to one of the most disturbing areas of our law. It's obscenity law. Our country just has crazy obscenity laws, in my opinion. This has been one of my biggest areas of publication and research because the average person, if you listen to them when they speak, they say fuck, shit, piss. They say the words like that all the time. I don't personally in my life. I don't use those words a lot except if I stub my toe or something or I get really upset. Most people use those words all the time, but on media we're not allowed to. In fact, you can get a $300,000 fine because those words are said to be obscene. And so there are two court cases that have determined that. One is Roth versus the U.S. Roth was a guy who ran a business of selling obscene material, and he was convicted of mailing that material using the U.S. Postal Office, that material basically being pornography deemed obscene, and there was a set of 3 standards that were developed to determine whether a work is obscene. The first one is the standard must be set by the individual community. What's obscene in New York may not be obscene in Dallas and vice versa. It's up to the local context. Secondly, the work must be taken as a whole. You have to know whether something that was said is out of context. Like if somebody says the word dick right? Is that a word that is being used obscenely, or is it when in the context of talking about somebody who expresses anger by expressing a word that is calling a male genital a pejorative term? That's not a healthy way to express your anger. That's a context, right? Roth says the context has to be considered. And finally, for something to be considered obscene, it has to be considered prurient. Prurient is this word that refers to an uncontrollable urge that people have. I don't know why they just don't use the word horny. That's a better word, but prurient is like a base, uncontrollable instinct where you reach out and do something that's obscene. So you got Roth versus U.S. Now, if you're saying to yourself, how can you know if something's obscene through those three standards? You're like most other people, and that's why a second court case had to be used to develop obscenity called Miller versus California. And this added 2 additional areas. Child pornography is illegal at any times, and material that has a serious artistic, literary, or political value cannot be banned. If it has serious value, again, looking at context. In the information age, it's really difficult to figure out whether obscenity has taken place as well, because the old laws base obscenity on local standards. But today, somebody can go and look at porn on a New York server, and they're sitting there in Idaho. So the internet has shattered the old way of trying to determine whether obscenity has occurred. And in fact, Larry Peterman is a person who found that out for himself. 1999, Larry Peterman owned a video store, an adult video store in Utah, one of the most conservative areas of the country, Provo, Utah, and he was charged with illegally renting obscene films. And so he decided, while his court case was taking place, to do a little experiment. What he decided to do was he made an arrangement with the hotel across the street to play adult movies on a pay-per-view channel, and then he collected the data. And he proved that far more people were buying movies in the hotel across the street than his video store. And so the jury acquitted him. The reason I think our law is so silly is because our ban on obscenity, and I also give you the example of that Swedish situation where I heard an American song playing obscenity right out in the open. Other countries do this. We don't. We don't allow obscenity in our mainstream legacy media. The result is you block it out, you bleep it out, and then people are invited to figure out what the word was that was just said. Or if you turn a female's body around, you only show her from the waist up behind, people are invited to imagine the rest of the body. That's the way that human nature works. And so you're actually creating more of a problem by banning and blocking these things, by exposing people more to them than if they had not existed. Let's move on now to copyright and fair use. Copyright and fair use. Basically, the law in this area says that in the digital age, you are allowed to download a copy of a song or a movie or any media content for free, as long as the website's not requiring that you pay for it. And if you only keep it for yourself, it's legal. However, once you start sharing it, then it becomes illegal. And there are 3 acts that get that across: the Copyright Extension Act, the Digital Millennium Copyright Act, and these speak to what copyright law is all about. Now let's move on to wrapping the class up. This one's a little bit long today, but I had a lot to talk about. We want to cover the rise and fall of broadcast regulation here. Broadcasters traditionally have been regulated more than print media. The argument has been based on this very strange argument that because broadcasters broadcast on a frequency, 92.5 for a radio station, or on television they have a frequency as well, those frequencies are limited. There are only so many of them. If you put too many radio stations on the FM band, they all start to interfere with each other. So since the spectrum, the frequency spectrum, has limited space, you have a privilege if you're a TV or a radio broadcaster. Therefore, you should be a person who has a higher responsibility to society, and therefore you can be regulated more in terms of obscenity and all these other areas. Very tough to figure that out, and in this age where you can get information from so many sources, and a newspaper can be read online anyhow. And so finally there has been a rolling back of regulations towards broadcasters, but They are still required to get a license, whereas newspapers don't. They are still required to file reports with the FCC. Newspapers don't. So broadcast regulation is still stronger than print regulation, but it's less than it was before. And one of the acts that helped loosen things up for broadcasters was the Telecommunications Act of 1996, a very big act, Telecommunications Act of 1996. The biggest thing that it did was it relaxed the rules on how many broadcast properties an ownership group can own. There used to be a limit. You can only own 4 in a big city. Now you can own a lot more. That's why iHeartMedia owns many radio stations in many markets. That's why NBC, Fox, all these other big companies, they own many more. And what that essentially did was it said that there's so much competition out there for media now that we need to reduce a lot of regulations for broadcasters. Otherwise, they won't be able to survive. People will be going to Netflix and iTunes and Yahoo and all the other places you can get media content. And so rules have been relaxed towards radio and TV as a result of the Telecommunications Act of 1996. And one rule that is still being talked about that has not been resolved, it's only an idea at this stage, is net neutrality. And what net neutrality is all about is you cannot charge different tiers of speed and service if you're a wireless cell phone company. You can't charge based on people and where they live. Like if you're living out in the middle of Pennsylvania in Schnecksville or some rural spot like that, there's not going to be as much service, broadband service, because there's not as many customers. So those people don't have access to as much high-speed internet service. And also Verizon and other companies can say if you reach a certain data limit, now your data is going to flow slower because we have a different tier. So the effect of this is to make it unequal in our democracy for some people to be able to engage in public discussion versus other people that have the money, that have the wealth, that live in the big cities. And that's what net neutrality is all about, is trying to bring equality to the net. It's not there right now. Even I, a person who considers to have a good income, a good job, I'm 59, I still have my data slowed by Verizon because of my plan, and that's not in the spirit of net neutrality. So there you have it, a lot of things to consider about today with law and the media. Have a great day.